Hello everyone, I am CA Dipin Mittal. On behalf of Taxmann Group, I welcome you all to today's webinar on taxation of digital economy. To provide us detailed understanding and explain various taxation aspects of digital economy, we are honored to have with us Mr. Sudipta Bhattacharya, Mr. Raghav Kumar Bajaj, and Mr. Jugal Mundra. First of all, I would like to thank Mr. Sudipta Bhattacharya. Mr. Bhattacharya is a partner in the indirect tax practice group of Khaitan and Company. He is recognized by the business world legal amongst the top 40 India's lawyer under the age of 40. With over more than 60 years of experience, he specializes in indirect tax advisory, including GST, customs, international trade laws, pre-GST indirect taxes, tax controversy management, and contract documentations. He has been recognized as highly regarded in indirect tax by World Tax, the comprehensive guide to world's leading tax firms, since 2020. He has also been repeatedly recognized as an indirect tax leader for India by the International Tax Review since 2017. He has authored a treaty on how GST applies vis-a-vis various types of EPC and construction contracts. This was published by Taxmann Publications. Mr. Bhattacharya advises many players in e-commerce and digital space. Thank you, sir, for taking out your precious time for this webinar. Next, we are also delighted to have with us Mr. Raghav Kumar Bajaj. Mr. Bajaj is a principal associate in the direct tax practice group of Khaitan and Company. He specializes in matters relating to digital taxation, tax dispute resolution panel, transfer pricing, and international tax. He advises clients in relation to tax-efficient structuring of inbound and outbound investments, tax due diligence, transactional tax matters, tax treaty analysis, and related aspects. He focuses extensively on cryptocurrencies and the underlying blockchain technology also. Mr. Bajaj was selected as IPBA Scholar for the year 2017 to attend the IPBA annual conference at Auckland. He was also named in the World Transfer Pricing Rankings. He is a regular contributor of articles, writers for professional magazines and journals, and also regularly speaks at webinars and seminars. Thank you, sir, for joining this webinar. We also have with us for this webinar Mr. Jugal Mundra. He is an associate in direct tax practice group of Khaitan and Company. He has secured all India ranks in CA examination and was awarded distinction for excellence performance in advanced diploma in international taxation conducted by Chartered Institute of Taxation UK. Thank you, Jugal. So, with this introduction, now I would be handing over this session to our panel of experts. But before that, I would like to inform all the participants that if you have any question, you can type that in chat box. All your queries will be taken during Q&A session at the end of this webinar. So now, without taking much time, I hand over this session to Mr. Bajaj. Over to you, sir.
Thank you. Hello, everyone. Welcome to today's session on taxation of digital economy and e-commerce transactions. Virtual economy has given way not only to unimaginable types of digital transactions, but also to a whole new economic arena consisting of multiple business participants. Smartphone usage has become the primary source of content consumption, encouraging newer avenues of digital economy like online advertising, data monetization, leading to an all-inclusive economic growth. And it's not just e-commerce that is being propelled by internet. The rapid digitalization is affecting all aspects of our lives and also how value is created and exchanged. In terms of numbers, reports indicate that the consumer digital economy in India is expected to reach $800 billion by 2030 from around $85 to $90 billion now. But internet usage trends vary across the globe. So for instance, while more than 80% of internet users in some European countries shop online, in many lesser developed countries, the corresponding share is below 10%. And if we talk about taxation of digital economy, it is a constantly evolving process because it acknowledges the fact that demand side factors are also significant contributors in the revenue generation for an enterprise, just like the supply side factors. And a key component of such demand side factors is data, the next oil. It is in this backdrop that the evolving tax regime for digital transactions and e-commerce needs to be understood. Now, today's session can be bifurcated into three parts. First, we'll discuss the key tax implications in relation to digital economy, direct tax and indirect tax. Then we'll understand the application of those tax implications in the form of some case studies. And then what are the key developments that one may look for in the field of digital taxation in times to come? One very important development that took place recently was the consensus amongst 136 countries for a two-pillar solution to address the tax challenges arising from digitalization of economy. We will walk through the statement that was released by OECD in this regard. Now, the first question that always arises is, why is digital taxation such a hyped and talked about topic? Well, the reason for all this hype could be multifold. Firstly, as you can see, this field is relatively new as compared to the other fields. Secondly, the pace at which digital economy has grown and at which it is expected to grow is unimaginable. Thirdly, the drivers of growth and the factors of contribution in digital economy are not the same as those in traditional economy sectors. So if you take, for example, in digital economy, factors like fast bandwidth, internet penetration, smartphone usage, all these are very important factors. But on the contrary, for the typical brick and mortar setup, factors like cheap labor, raw material, etc., all these will be important factors. And lastly, in some sense, you can say that digital economy is locationless, and therefore it becomes extremely difficult to identify the real jurisdiction and the point of time in which value can be said to be created. It is for all these reasons that the existing set of tax laws, which were primarily set on a physical presence based nexus rule, became ineffective and inadequate for digital economy. And since in e-commerce, users are a very important revenue generating factor, it meant that the traditional tax regimes had to be updated so that market jurisdictions also get the right to tax profits which are arising to foreign enterprises from their virtual presence. If we look at what have been the key events in the digital taxation journey, I think it would be fair to say that the OECD BEPS project laid the most important foundation in the field of digital taxation. Action 1 report of BEPS project dealt with the tax challenges arising from digitalization, and it laid down that countries could introduce any of the following three options in their domestic tax laws as additional safeguards against BEPS, provided they respected their existing treaty obligations. Number one, a new nexus in the form of a significant economic presence, that is SEP. Number two, levy a withholding tax on certain types of digital transactions. Or number three, to introduce a new tax called as Equalisation Levy. But interestingly, India left no stone unturned and adopted all these routes to tax the virtual economy. In terms of timeline, first came Equalisation Levy in 2016 in relation to online advertising. This can be called as EL1 because in 2020, a wider variant of Equalisation Levy was introduced, EL2, on e-commerce supply or services. Now, this has been introduced outside of the Income Tax Act, hence treaty protection is not available in this regard. The second one, SEP, it found its place in Income Tax Act in 2018. While the principal provision was introduced in 2018 itself, the applicability of it was deferred to make it applicable for FY 21-22 and onwards. And then the withholding tax section 194O got introduced in the statute book in 2020. So let's examine these legislative amendments one by one. Significant economic presence, short formed as SEP, is a new nexus rule in Income Tax Act to cover a foreign enterprise if it crosses certain prescribed thresholds in terms of India-centric payments or user base. Since this is a domestic law provision, it continues to be subject to tax treaty protection. So from a practical perspective, SEP would be relevant only for those taxpayers who come from a non-treaty country or for those taxpayers who are not eligible to tax treaty benefits. Now, SEP test was introduced in two forms, a payment-based and a user-based. Once the test is met, income which is attributable to the SEP-based activities will be deemed to accrue or arise in India. Now, as you can see, the payment test provides that transactions carried out by a non-resident with any person in India will constitute SEP if the aggregate of payments arising from such transactions during the financial year exceeds 2 crore rupees. Now, when SEP was originally introduced, it required a transaction to be carried out by a non-resident in India. But the substituted version states that the transaction carried out by non-resident with any person in India would constitute SEP. So basically, the earlier requirement of the non-resident transacting in India has been changed to a non-resident having transaction with a person in India. And that's what you can see on your slide. The text in red font that denotes the changes which have been made over the life of SEP provision. The second form of SEP deals with systematic and continuous soliciting of business activities or engaging in interaction with at least 3 lakh users in India. Now, there's an interesting bit on this aspect also. When SEP was originally introduced, both the activities had to be carried out through digital means. But the phrase through digital means, as you can see, was omitted by Finance Act 2020. So what this means is that the final version of this user-based SEP covers digital as well as non-digital interactions of a foreign enterprise with India. If we talk about income attribution rules, under the Income Tax Act, if a foreign enterprise has business connection in India, then the income which is reasonably attributable to the operations in India is taxed here. Now, what has happened in the past few years, discussions have been going on in international forums, wherein countries have generally agreed that revenue from digital advertising or data monetization should be accounted for in source countries' revenue. And in line with this principle, our Income Tax Act has also been amended to provide that income from advertisement that targets Indian customers, or income from sale of data collected from India, or income from sale of goods and services using such data will be deemed as income attributable to India and basically taxable in India. If we talk a little bit more about these 3 categories, in the first category, the mode of advertisement is immaterial. What do I mean by that? So I mean that advertisement could be electronic, digital, physical, anything. The main criteria is that it should be a targeted advertisement. And interestingly, customers' residential status is not relevant. What is relevant in this category is that the customer's presence is in India. The second category, that is the sale of data, what is relevant here is that there should be a sale of data which has been collected from the specified persons. And if we talk about the third category, so now that covers sale of goods or services using the data which is mentioned in the second category. For this category, there has to be a connection between the India-centric data and the sale of goods or services. So as you can see, the income attribution rules have also been widened to provide that income from these different activities will also be regarded as income attributable to India. If we move on with respect to Equalisation Levy. Now, Equalisation Levy was introduced for the first time in our tax laws in 2016. Let's call this version as EL1. Because it was introduced as a digital services tax or a transactional tax, basically a new levy of 6% on non-residents receiving consideration for rendering specified services, basically online advertising, to an Indian resident carrying on business or profession, or to a non-resident which has a permanent establishment in India. Interestingly, for the purpose of this EL1, the relevant factors are the person to whom the consideration is paid and the person who pays the consideration. Factors like location of target audience, whether the customers are in India, etc., are irrelevant. If we talk about exemptions, there are certain transactions which have been excluded from EL1. First being a situation where the non-resident service provider has permanent establishment in India and the specified services connected with such PE. Second being a situation where the amount of consideration does not exceed 1 lakh rupees. And third being a situation where the payment for the specified service is not for the purpose of carrying out any business or profession. So if you can see, the exemptions or exclusions talk about different fields. One exclusion is dependent on the residential status of service provider. Then there is a monetary limit. And then third is dependent on the use. In terms of operations and compliance, EL1 was introduced like a TDS provision, wherein the payer is required to deduct the EL and pay the same with government on a monthly basis. To avoid double taxation, Income Tax Act has been amended to provide that income arising from the specified services which are chargeable to EL1 will enjoy a corresponding exemption under the Income Tax Act. So what this means is that if EL1 is leviable on something, then normal income tax will not be leviable. But for completeness, I think I should just point out that if something is taxable as royalty or FTS, that's fees for technical services under the Income Tax Act, read with the applicable tax treaty, then that is out of the purview of EL itself. If we talk about some aspects in relation to how the EL1 came into being, so the Committee for Taxation of E-Commerce, the list of specified services which were recommended by this committee was very wide, and it included other services also, like online collection or processing of data related to online users in India, use or right to use or download online content, etc. But in the fine print of law, only online advertising related services were covered, with enabling power given to the government to notify other services also for this category. The second category of equalization levy, EL2, which was introduced in our tax laws by Finance Act 2020, is very interesting. Firstly, it was not mentioned in the Finance Bill 2020, so the legislative intent behind its introduction is not available. Secondly, this expanded scope was introduced by way of a separate charging section, that is section 165A. Now, EL2 creates a new equalization levy of 2% of the amount of consideration received or receivable by an e-commerce operator from e-commerce supply or services made or provided or facilitated by it to a person resident in India, or to a non-resident in the specified circumstances, or to a person who buys such goods or services using IP address located in India. So if you'll note that there are multiple elements in this definition, and we'll touch upon each element one by one. But for ease of reference, let's call this expression e-commerce supply or services as ESS. So what this means is that ESS made or provided or facilitated to an Indian resident is always covered within the ambit of EL2, but ESS to a non-resident is covered in EL2 only in certain specified circumstances. And what are those circumstances? Sale of advertisement which targets Indians, or sale of data collected from Indians. Now, if you note, in relation to the advertisement criteria, it could be practically impossible for the non-resident e-commerce operator, and I'll tell you why. That's because this levy depends upon the residential status of the customer, that is, whether the customer is resident or non-resident. Now, practically, just consider yourself as a customer for a minute. The non-resident e-commerce operator will not have any idea as to the residential status of the customer. What e-commerce operators will generally have is our location. So from a practical perspective, there will be some teething issues in relation to complying with this provision. Evidently, as I said earlier, there are a lot of elements in EL2 which need to be understood carefully. So firstly, e-commerce operator, that means a non-resident who owns, operates, or manages digital platform for online sale of goods or online provision of services. Some common type of platforms could be social media platforms, e-commerce platforms, etc. Secondly, the e-commerce supplier services. That means online sale of goods or online provision of services, either owned or provided by the e-commerce operator itself, or facilitated by the e-commerce operator, or any combination of these activities. Now, if you note, this definition itself is very wide. But if you see this explanation, the legislature did not stop at the main part of the definition. There is an explanation also to this definition, which states that for the purpose of this clause, online sale of goods and online provision of services will include one or more of the there's a laundry list of online activities, namely acceptance of offer for sale, placing of purchase order, acceptance of purchase order, consideration payment, etc. So what this means is that the mere act of an online placing of order has also been deemed to be equivalent to the online sale itself for the purpose of EL2. Importantly, the law also provides that consideration received or receivable from ESS will include consideration for sale of goods, consideration for provision of services, regardless of whether e-commerce operator owns the goods or provides the services, etc. Like EL1, there are some exemptions from EL2 also. First, where the e-commerce operator has a permanent establishment in India and the ESS is connected with such PE. Second, where EL1 is leviable. And third, where the sales, turnover, or gross receipts of the e-commerce operator from the ESS referred to in this regard is less than 2 crore rupees during the financial year. In terms of operations and compliances, unlike EL1, which was introduced like a TDS provision, the liability for compliance with EL2 rests with e-commerce operator, that is the foreign enterprise. And to avoid double taxation, just like EL1, Income Tax Act has been amended to provide that income arising from ESS, which is chargeable to EL2, also will enjoy a corresponding exemption under the Income Tax Act. As you would have noted, the manner in which EL2 is worded is very wide. In fact, the currently used language can cause EL2 implications for intra-group transactions also. And in fact, that is one of the case studies that we are going to discuss in the coming slides. The third bit of legislative amendment deals with the TDS on certain e-commerce transactions. Section 194O, now that was inserted in Income Tax Act to introduce a new TDS requirement of 1% with effect from 1st October 2020 on an e-commerce operator if it facilitates the sale of goods or provision of services of an e-commerce participant through its platform. Now, this 1% TDS is to be computed on the gross amount of such sales or services, and that is a very important element in this withholding tax section. Now, basically what is happening is that this section is making the e-commerce operator as the nodal point of contact for Income Tax Department. So just imagine any typical online marketplace model where an e-commerce operator facilitates the transactions through its platform. In all those setups, this TDS requirement will get triggered. Just like SEP and EL, there are some key points to note regarding this provision as well. So firstly, in relation to e-commerce operator, the 1% TDS applies to resident e-commerce operators as well as non-resident operators. So the scope of this TDS provision is very wide. Secondly, this TDS is applicable only if the e-commerce participant is an Indian resident. So basically, if the sale of goods or provision of services on the platform is done by a non-resident, then this TDS will not apply. The third element is, in relation to the e-commerce that is being referred to in this section, which is supply of goods or services, including digital products. Now, digital products is something which is not defined, and therefore this may constitute some discussion in times to come. But generally understood, we think that items like e-books, images, e-coupons, etc. may fall within this ambit. In terms of operations, Section 194O also provides that if there is some payment made directly by the customer to the e-commerce participant, then that also triggers the TDS obligation of the operator. And practically this aspect will be extremely difficult to comply with by e-commerce operators and may lead to some complex issues. You can think of any example where you're calling some service provider from an e-commerce platform, and suppose if after that person comes to your doorstep and you make some payment directly also to him or her, then there is a simultaneous TDS obligation on the e-commerce platform. That's why this will be a very difficult provision to comply with. In terms of exclusions and exemptions, this TDS is not applicable if the e-commerce participant is an individual or HUF, provided that the gross amount during the financial year does not exceed 5 lakh rupees and such participant has furnished its PAN or Aadhaar number to the e-commerce operator. Moreover, the CBDT circular, which came last year, Circular 17 of 2020, also excludes certain transactions such as transactions in securities and commodities which are traded through recognized stock exchanges, payment gateways, insurance aggregators, etc. To avoid double TDS levy, Section 194O also provides the transactions covered by this section are exempt from TDS under all other provisions of Chapter 17B of Income Tax Act. With this, we move on to the last bit of sort of legislative provision in relation to digital taxation. Now, any discussion on digital taxation, I think, would be incomplete without mentioning the recent Supreme Court decision regarding software payments. Briefly stated, the issue was whether such payments are for copyright or copyrighted article, and there were divergent views in this regard. Now, this was critical because the manner of characterization had a direct bearing on whether such payments will fall within the ambit of royalty or business profits. And this had a consequential effect on the applicability of withholding tax provisions also. So the Honorable Supreme Court analyzed this issue in light of our Copyrights Act, and after considering all aspects, it ruled in favor of taxpayers. It held that the end user was allowed to use only the software product and that there was no transfer of interest in the copyright of the software. Basically, the court acknowledged that the essence of the transaction was of sale of copyrighted article and did not qualify as royalty under the relevant tax treaties. Uh, of course, this came as a sigh of relief for many taxpayers. Now, with this background, I am sure that it is evident that now the direct tax legislation at least has many teeth when it comes to the taxation of digital economy and e-commerce transactions. Now, I'll request my colleague Sudipta to give us a glimpse of what the indirect tax laws have in store for us in this regard. Over to you, Sudipta.
Sure. Thanks, Raghav. Very good afternoon to all of you. See, when we talk about GST, it is a transaction tax, right? It is the implications vary from supply of goods and supply of services, and whether or not something is in the physical world or in the virtual world, that more or less remains the same. But there are two specific concepts under GST which are very, very particularly dedicated and focused towards digital transactions. One is OIDAR services, online information database access and retrieval services. The definition of it is on your slide. What it tries to cover is scenarios where the delivery of the service is mediated by and dependent upon information technology, where the service delivery is essentially automated and involves minimal human intervention. And we'll discuss what is minimal human intervention in a couple of minutes. And the examples that are given are, internet advertising, cloud services, digital data storage, online gaming, etc. Very important to remember that OIDAR services, if you see the definition, comes from IGST Act and not the CGST Act, because it is a concept that is relevant only from a place of supply perspective. If you look at the classification of services, or even the explanatory notes vis-a-vis classification of services, you won't find a specific mention of online information database access and retrieval. In fact, some of these specific services that are mentioned in the inclusive part of the definition, whether it's advertising, whether it's provision of music, software, etc., or online gaming, gambling, stuff like that, all of them have specific specific classification under the classification of services that is provided under the CGST Act. So this comes in handy. This becomes relevant when when we are talking about a foreign supplier providing services in the nature that falls under the definition of OIDAR, and the recipient in India is an individual, like people like you and me, who are using it not for business or commerce or profession purposes, but purely for a personal consumption. So, and this concept, and this is a pure digital transaction tax in the sense, and similar concept exists even under European Union VAT, in as much as they also talk about electronic services, electronically supplied services, and in fact, the test of human intervention, minimal human intervention, has almost verbatim been borrowed from EU VAT. And the concept that it is the service provider from outside the taxable territory of the recipient who has to go and register in the taxable territory, in our case India, either by on their own or through a representative, is also comparable to Europe. So this is how the taxing jurisdiction is trying to tax on the basis of consumption, tax on the basis of how much earnings are happening from a particular market for a digital service provider. So this is one concept that is very specific to digital OIDAR. The next is, of course, e-commerce operator. Now, e-commerce is also defined under GST in a fairly generic sort of way. E-commerce operator is defined in a slightly more specific manner. It says means any person who owns, operates, or manages digital or electronic facility or platform for electronic commerce. So the emphasis is not only on ownership, but anyone who operates or manages would also qualify as electronic commerce operator under GST. Two specific obligations can emerge from this. One, of course, is TCS obligation, tax collection at source. So if an electronic commerce operator acts as a platform, as a marketplace, and connects buyers and sellers of particular goods or services, and also collects payments for those goods or services for further remittance to the supplier, in that scenario, for every supply that gets routed through this particular platform, 1% has to be deducted as a TCS by the e-commerce operator. This is less a tax collection mechanism, more a tracking mechanism to keep track of the volume of online transactions, and to ensure that suppliers who supply through digital platforms are also discharging their GST liability. The second way it manifests itself is under Section 9(5) of the GST Act. 9(5) is a lot more specific thing where if an e-commerce operator is intermediating certain types of notified supplies, the e-commerce operator steps into the shoes of the supplier and becomes liable to pay GST itself on the supplies being intermediated. Classic example is, of course, the likes of Uber and Ola vis-a-vis passenger transport services, which is one of the first categories to be notified under 9(5). Other categories are housekeeping services, restaurant services by the likes of Zomato and Swiggy are about to be notified. So 9(5) is a second sort of manifestation or a trigger point once someone qualifies as an e-commerce operator. So OIDAR relevant when someone from outside India provides services of an assorted digital nature to individual customers in India. An e-commerce operator has two sort of relevant touch points. One is the tax collection at source obligation, and second is 9(5) obligation for those 3 or 4 notified categories. If we sort of take a few examples to identify or better understand this concept, I think Netflix is, of course, a very obvious example of OIDAR. Uber and Ola, like I mentioned, are popular examples under Section 9(5), and companies which are functioning as e-commerce operators, Amazon, Flipkart, and many, many more who operate as marketplaces under this. One concept or conceptual point that comes up is, and this is a topic that's close to our hearts, cryptocurrency exchanges. Many of us are investing in cryptocurrency these days, often through foreign exchanges which are located outside India. And the question that arises is, are those exchanges liable to fall under OIDAR, liable to GST in India after registering? Prima facie, if you look at the definition, most of the trading that happens is algorithm based, is automated, and to that extent has minimal human intervention, and to that extent likely to fall under the definition of OIDAR. While each case, of course, needs to be looked at separately and independently, the government definitely does feel that foreign cryptocurrency exchanges qualify under OIDAR and ought to take registration in India themselves or through representatives and discharge GST. Many of the India-based exchanges are depositing GST on the transaction fees that they are charging for the exchange-related services. So I think it's only a matter of time that the foreign cryptocurrency exchanges are also forced to toe the line. One particular case law, since we mentioned about minimal human intervention in the context of OIDAR, what does it mean? What is the threshold for minimum human intervention? I think there is the advanced ruling in the case of NCS Pearson is particularly relevant to understand that, at least how an advanced ruling authority, or maybe the department, because advanced ruling authority, as we all know, more or less mirrors the thinking of the department. It's crucial to have a look at this. NCS Pearson basically were providing online testing services to students. Two types of tests are relevant for our current discussion. Type 2 on your slide, on the middle of the slide, where candidates enroll themselves on the applicant's portal. Applicant provided location. Applicant here is NCS Pearson. So NCS provided the location of the test center. Candidates visit the test center where there is a human invigilator who checks the identity. Once the test is completed, the scores are immediately provided through a software-based automated process. So only one level of human intervention, which is the human invigilator who checks the identity at the once student reaches the test center. The second, type 3, is very similar to this, but there is additional layer of human intervention in as much as type 2, the test questions are multiple choice questions. Here, the questions are essay type. And there are two levels of marking, or two parallel sort of ways of marking, one by a human expert, another by a machine or by an algorithm. And if there is a difference beyond a particular threshold between these two, then a third human expert is called in, and his marking is considered as final. So as we see, there are there is an additional layer of human intervention. One is invigilation, second is in the marking process. In the marking process, human and machine combine together to provide the scoring benchmark for the student. The question before Advanced Ruling Authority, of course, was will this qualify as OIDAR? For Type 2, the Advanced Ruling Authority held that Type 2 qualifies as OIDAR because there is minimal human intervention. Type 3 does not because the Advanced Ruling Authority felt that the threshold of minimal human intervention has been breached by this additional layer of human intervention. The department appealed to the appellate authority, and the appellate authority for advanced ruling held that even Type 3 qualifies as OIDAR and meets the test of minimal human intervention. What they did is, they referred to the European VAT Committee's commentaries, etc., or preparatory discussion material. Because if you remember, we saw that even under European Union VAT, the concept of minimal human intervention exists. So they went behind the explanatory notes vis-a-vis that concept, and they say that you have to judge human intervention from the perspective of the supplier, not how much the customer is interfacing with a human being, but on the side of the supplier, if a package of service is being provided, how much is the role of human intervention in delivering that entire package of services. And with that perspective, they said that scoring by the human was being done in tandem, in coordination with the algorithm, with the software. So the scoring part of it or the invigilation part of it is only couple of small pieces in the overall package of online test services being delivered. And to that extent, it falls within the threshold of minimum human intervention, and thus Type 3 also qualifies as OIDAR. So what they did effectively is give the maximum possible stretch to minimal human intervention. While we may or may not agree necessarily with this conclusion or this wide reading of minimal human intervention, at least we now know how the department thinks of it. And one last point I want to touch upon before we go to the case studies. This is a fairly specific issue of import of intangible goods. What happens is, when we import a software, we may do it in a CD, DVD, etc., or a pen drive, and it's an import of a tangible goods on which customs duty gets paid. What happens when a software is being downloaded? And I'm not talking about a service transaction. I'm not talking about a license transaction. I'm talking about a purchase transaction where I become owner of the software, not the copy of that particular software, but the software per se. Raghav explained the distinction as explained by the Supreme Court. So keeping that in mind, if I am doing an import of goods, what is the taxability? There is a moratorium signed by all WTO countries, including India, of not imposing customs duties on electronic transmissions. So basically, basic customs duty will not be levied on electronic transmissions on import of intangible goods. What are the two typical taxes that apply on import of goods? BCD and IGST, right? So if BCD is not leviable, does that mean no IGST would be leviable either? The reason I raise this point is, if you look at the source of this IGST levy on imports, we have to first go to Section 5, first proviso of the IGST Act. That says integrated tax on goods imported into India shall be levied and collected in accordance with the provisions of Section 3 of the Customs Tariff Act. Levied and collected. So they seem to be diverting it back to Customs Tariff Act. And Section 3 of Customs Tariff Act gets triggered in the same circumstances as Section 12, the charging section under Customs Act gets triggered. Which simply put, it means that if there is no customs duty leviable, no basic customs duty leviable on import of intangible goods, there should be no duty, no IGST being levied under Section 3 of Customs Tariff Act either. This can lead to, in specific transactions, fairly significant implications. It has not yet been tested, except for a recent SESTAT judgment which came in, but in a different context, in the case of Intra-Group Aviation Limited. So here it was the Delhi bench of the SESTAT. What they said is integrated tax is levied under Section 5 of the IGST Act but is collected in accordance with provisions of Section 3. Thus, integrated tax is levied under Section 5 and only the procedure for collection has been provided under Section 3. Now, with the greatest of respect, the Honorable Tribunal seems to be concluding something that flies in the face of the clear words of the statute. The statute proviso 1 of Section 5 is very clear that integrated tax shall be levied and collected in accordance with Section 3 of Customs Tariff Act. Given that, I frankly was quite surprised to see this particular conclusion from the Honorable Sestat, which say that the levy is under Section 5. It's just the procedure for collection which has been prescribed under Section 3. I believe this is not the last we have heard on this particular issue. This has been appealed against, and depending on what conclusion the higher courts reach on this particular thing, the taxability of intangibles I'm sure we'll see a lot more development on that front. Because as we stand today, notwithstanding this Intra-Group aviation judgment, I believe that there is a credible argument to be made that when we are importing intangible goods, that can be in the form of a software, that can be in the form of a purchase of trademark or purchase of any other intellectual property, okay, as opposed to license. This concept is worth exploring, or this proposition of law is worth exploring. So I think this is one area where we don't have a conclusion yet, but given that this issue has already come up in a slightly different context in Intra-Group aviation, I'm hopeful that we will see a lot more action on this point in the coming days. With that, I'll request Raghav to introduce the case studies.
Thank you, Sudipta, for that wonderful insight into the indirect tax laws. I'm sure by now we have understood the direct tax and GST provisions in relation to the digital economy taxation. So let us proceed to see their actual application and examination on different types of e-commerce transactions. And on your slide, we have written the 4 case studies that we are taking today, like software as a service, online gaming, online database subscription, online advertising. These are some of the most common transactions that are taking place in digital economy in the digital economy ecosystem. And because of the multiplicity of taxation provisions, be it direct tax or indirect tax, which are applicable to them, different interpretational views cannot be ruled out. You would have heard Sudipta mentioning about the different types of implications and interpretations which are possible in relation to indirect taxes itself. When we talk about now, when we'll see about the direct tax bit also, like how the interplay between significant economic presence, EL1, EL2, royalty, FTS, all that will be played out. So it becomes extremely important for us to have an overview of these types of transactions. Now I'll request Sudipta and Jugal to walk us through this segment and explain us what are the taxation issues which one encounters generally in relation to such digital transactions. Let me tell you, this is going to be a very interesting segment of today's session. Over to you, Sudipta and Jugal.
Thank you, Raghav. Good afternoon, everyone. So moving to the very first case study, which is on online advertising, and we've kept it the facts as relatively simple for us to understand the concepts. So the fact here is that FCO, which is foreign company, is assisting ICO, Indian company, in making online advertisements that are used by ICO for promoting sales of its products. Now, the issues we've considered for examination here are, number 1, will equalization levy be applicable? If yes, will it be 2% EL or 6% EL? Second question, will income tax be applicable? Because as we know, income tax is a different tax, or rather EL is a different tax from income tax. And the third is whether ICO would be liable to deposit GST on the services supplied by foreign company. Seeing the direct tax aspects first, and so first, as we discussed earlier, equalization levy as a chapter does not apply if the services can be classified as royalty or fees for technical services, which is FTS. So therefore, the first determination to be undertaken is whether the service will be classified as FTS under the relevant tax treaty read with the IT Act, because this service is not unlikely to fall under royalty. So we've narrowed down our focus to FTS. And if it is FTS, then EL should not apply due to the amendment introduced to Finance Act 2021, which is that if the service is EL exigible to taxation as FTS or royalty, then EL does not apply. Now in FTS, as we know, there are under the Income Tax Act as well as under tax treaties, three kinds of services are normally classified under FTS. One is managerial, second is technical, and third is consultancy services. Now, this service in the present tax is unlikely to qualify as a managerial service or, for that matter, as a technical service. However, whether the present service would be classified as consultancy service, that would be a key determining factor in deciding whether it is FTS or not. And for that, we would, of course, need to see the specific facts of the case in terms of what is the exact nature of service being provided by FCO to ICO. Now, that said, once the income tax applicability is decided, then you move to EL, and you move to EL rather only if the service does not qualify as FTS. Now, looking at the EL applicability on a standalone basis, assuming that it does not qualify as income tax, the definition of specified services on which 6% EL applies are online advertisement, any provision for digital advertising space, or any other facility or service for the purpose of online advertisement. Now, the words that we have emphasized here, underlined and bold, that would be relevant here because the service provided here is FCO assisting ICO in making the online advertisement, which may be classified as being a service which is for the purpose of online advertisement. And this would, of course, again depend on the specific facts, whether at the time of entering into the agreement itself, it was decided that ICO would be using the services of FCO for the purpose of online advertisement itself, or the advertisement was a general advertisement which was then also used for displaying through the online medium. And once 6% EL applies, so the priority is first to see whether royalty or FTS will apply. The second is whether 6% EL will apply, and then you check whether 2% EL will apply, right? And so once 6% EL applies, 2% EL does not apply due to a specific exclusion. And so it is unlikely to not fall either under FTS or, for that matter, under 6% EL, and so therefore 2% EL analysis does not really become too relevant in the present facts. Sudipta, request you to please cover the indirect tax aspects of this.
Sure. I think the indirect tax part is fairly simple. We don't have that many interplays in this one, given the simplicity of the OIDR concept. Now, undoubtedly, this will qualify as OIDR because it's one of the specific categories mentioned in the definition, as we saw. But what will happen is here we are talking about the recipient here is ICO, who is a business entity, who is a registered corporate. It is not a non-taxable online recipient. Non-taxable online recipient, if you look at the definition, would be basically people like you and me who are using it for personal consumption, basically other than for commerce industry, business, profession, etc. in the taxable territory. If you look at the definition, it says means any government, local authority, governmental authority, and individual or any other person not registered and receiving OIDR services in relation to non-business purposes. So I think these are the only categories, and clearly ICO is unlikely to fall under non-taxable online recipient. And to that extent, while it will qualify as OIDR, FCO would not need to take a registration in India and charge GST. Most likely it is going to be a reverse charge, and ICO will need to pay GST on a reverse charge basis.
Thanks, Sudipta. So moving on to the next case study, which is on online database subscription. Here the facts are that ICO, Indian company, is engaged in manufacturing pharmaceutical products. FCO, foreign company, provides the following online database access services to ICO. Number one, they provide marketing research reports of the pharma sector, which are collated from various sources. And number two, they also provide chemical information, including articles on chemistry topics and substance-related data. Now, the issues we've shortlisted for examination are: number one, will 2% EL be applicable? Number two, will income tax be applicable? Third, whether the services supplied by FCO would qualify as OIDR services. And number four, whether FCO would be liable to deposit GST on the services supplied by it to ICO. Now, first dealing with the direct tax aspects. As we discussed earlier, in terms of priority, first is to check whether FTS or royalty. If not, then move to 6% EL, and if not, move to 2% EL. Now, here we can analyze it from royalty as well as FTS perspective. Now, various judgments have held that the nature of services provided by FCO to ICO do not constitute FTS, as they do not involve any technical service requiring human intervention. One of the tests laid down by the Supreme Court for determining FTS is whether human intervention is involved or not in providing that service. In online database subscription, it is unlikely that the provision of the service itself would have any human intervention, and so the FTS angle can be viewed that way. As regards royalty, two aspects need to be covered. Number one, here the payment is for a copyrighted article and not for copyright of the database. And so the royalty definition, as we know, has multiple limbs to it. One is, where payment is made for copyright of for rights to copyright of a literary work, etc. So that limb of the royalty definition is unlikely to be satisfied. And that is in light specifically that debate has now been settled in view of the Honorable Supreme Court's judgment in Engineering Analysis Center of Excellence. And now but the second aspect of the royalty definition, which is particularly relevant here, is whether the information over the service provided here constitutes information concerning industrial, commercial, or scientific experience. Now, these words are also another part of the royalty definition given in the IT Act as well as the treaties. Now, some judgments have used the test of previous experience in deciding whether a particular service falls within this limit. Now, what is this test of previous experience? It basically says that if the information was acquired by previous experience of the information provider, then in that case, it should fall within this particular limb. If it is simply an aggregation of information by the provider, that is, it does not really entail previous experience done by the service provider. Let's say in our facts, FCO has really not done any marketing research itself, or by itself, it has not gone into the market and obtained chemical information. It is just aggregating information from various sources. Then in that case, it would not meet the test of previous experience. And the interesting part here is that India's position, so firstly, this test of previous experience is outlined in the OECD commentary, and it has also been followed by a number of judgments. Now, the interesting part is that India's position in the OECD commentary on this is that test of previous experience should not apply while deciding applicability of this limb of the royalty definition. So this is how one can view this, and again, depending on the specific facts and detailed analysis, one can come to a conclusion on whether royalty would apply or not. Now, that said, next analysis would therefore be equalization levy. So again, relevant only if the service does not qualify as FTS or royalty. Now, online database subscription service should qualify as online provision of service. As we saw, ESS, e-commerce supplier services, either online sale of goods or online provision of service. And definitely an online database subscription would classify as online provision of service. And hence, this should be exigible to 2% EL. Of course, satisfaction of other conditions such as the 2 crore limit, not having PE, etc., should also apply. And needless to mention, 6% EL would not be applicable here because the facts here do not involve any online advertisement. Sudipta, if you could cover the indirect tax aspects here.
Right. So it's more of the same. I mean, because this also clearly qualifies as YDAR, and in this example also, ICO would not qualify as a non-taxable online recipient. So the implications remain the same as the last transaction, i.e. it qualifies as YDR, but it will be liable to be paid on a reverse charge basis by ICO. FCO does not need to take a registration and be liable to pay GST on a forward charge in India.
Thanks, Sudipta. Now moving to the third case study, which is now moving to a slightly complex case study and an interesting one, is the case study of online gaming. And we've specifically narrowed down here on the example of online betting. Now, gaming could have multiple formats, but we are specifically dealing with online betting in this case study. Now, As we know, online betting, gambling, lots of developments happening there in terms of regulations being introduced by different states, legalizing or illegalizing certain aspects of it. But as we know, various websites are run by non-residents, operating in the field of online betting. So, I mean, because the general rule is that in India, wagering is considered as illegal unless specifically allowed. So non-residents are mainly the ones who are operating in this field. So in this example, it is assumed that Mr. X, who is an Indian resident, is betting against the house, which is, so house here basically refers to the online betting website itself, which is being run by the non-resident. And no service fee or entry fee is being charged by this website. Anybody can come and play once they deposit a certain minimum amount in their wallet. The issues we are considering over here for examination are, equalization levy. Will the 2% EL be payable by the website? And number two is whether the non-resident hosting the website, which is conducting online betting, would qualify as an OIDAR service provider. In terms of the specific, amount that we've used here, we've said that as the first step, Mr. X will deposit 1,000 rupees in the e-wallet, and then he places a bet of INR 1,000 with odds of 1/2, which means that if he wins the bet, the website will pay INR 1,500 to Mr. A, and if it's the other way around, Mr. X will lose 500 rupees there. Now, coming to the direct tax analysis, first is with relation to 2% EL. Now, again, as we saw, priority-wise, FTS royalty is the first one, should not apply here because there's no service fees being charged here, and neither does placing a bet fall within any limb of FTS or royalty. The 6% EL also should not apply here because there's no online advertising being involved, and so straight we move on to analyzing 2% EL implications. Now, for 2% EL to apply, the website and its activity should satisfy the definition of e-commerce operator and e-commerce supply services respectively. To satisfy both the definitions, either there has to be online sale of goods or online provision of services. Now, in fact, one of the questions we're seeing in the chat box, related to online gaming, and so whether the provider would satisfy the e-commerce definition. So, I think the following part should answer that question. Now, so let's deal with it one by one. Does online betting entail any online sale of goods? So goods are not defined in equalization levy provisions or under the Income Tax Act. Goods are defined in the Sale of Goods Act as goods, meaning every kind of movable property other than actionable claims and money. So actionable claims have been specifically excluded from the definition of goods under the Sale of Goods Act, and goods are also defined under the Constitution of India and has a very wide meaning there. So therefore, here, since it's not defined in EL or the Income Tax Act, goods would need to be given a general meaning in that sense. And so if the Sale of Goods Act is specifically excluding actionable claims, it is worth analyzing whether what is actionable claim, and whether if once it is an actionable claim, whether it falls within the general meaning of goods. So actionable claims are defined in Section 3 of the Transfer of Property Act as claim to any debt which the civil courts recognize as affording grounds for relief. That's, I think, the part which is hidden there. I mean, because we've kept the camera on, but basically says a claim to any debt which the civil courts recognize as affording grounds for relief, whether such debt or beneficial interest is existing, accruing, conditional, or contingent. And the last words, which is conditional or contingent, would be very relevant here, because the debt here, so in this fact, let's say, how is this an actionable claim? Mr. X is, let's say, placing a bet, and if he wins the bet, he is to receive 1,500 rupees from the website. Now that debt of 1,500 rupees is, of course, conditional or contingent on him winning the bet, right? So therefore, that specific aspect is the last words are important here. And since actionable claims are specifically excluded from the definition of goods, question is whether actionable claims are within a general sense. And two judgments of the Supreme Court are very helpful here. One is the case of Sunrise Associates, which is a couple of years back, and Skill Lotto Solutions Private Limited, which is a very recent case of 2020, where it has been held that actionable claims are goods in the general sense. And so once we come to a conclusion that the bet placed here is an actionable claim, then we can perhaps take a view that they also qualify as goods. But then the next question is whether there is an online sale of goods. And a sale of goods generally implies transfer in the ownership of property of goods. In the present facts, a position can be taken that the actionable claim, which is betting in this case, is not really owned by the website, but in fact is coming into existence only when the bet is placed by Mr. X. And so therefore there is no transfer or sale, but only a creation of actionable claim at the time of placing the bet. And in fact, there are some judgments. A similar analogy can be taken from issue of shares, where it has been held that when you are allotting shares, fresh allotment of shares for the first time, there's really no transfer of shares in that case. It's a creation. One of the landmark Supreme Court judgment, I think Koda De Distilleries, has held that. So on this basis, a position may be taken that there is no sale of goods taking place on the website. But the next aspect to be really considered is, does online betting entail online provision of services? And again, two views are possible here. View one is that since customers are betting against the house, no element of service is involved, and online betting cannot be considered as provision of service. So let's say I place a bet against you, right? And so am I providing a service to you? Many would say no, that's not really a service. That's one way of looking at it. And the other way of the view two is that the website is providing a service in the form of access to the website. It is doing multiple things for the customer, such as what? It is providing access to the website. It is facilitating the entire process from setup of accounts to settlement of debts. It is ensuring protection of customer data. Hence an online service is involved. So that's, two views are possible in this fact. But even if you assume that the online betting does entail ESS, e-commerce supplier service, what is the consideration or taxable base on which EL should apply? The first view is that 2% EL should be levied on the bet amount of INR 1000 on the basis that online betting has a service element, which is embedded in the overall commercial arrangement or business model of the bet money being received. So that's view one. And the second view is that since no service fees is being charged, no consideration is really being received by the website, and hence EL should not apply. Now again, here it would also depend on the specific facts in terms of the other documents also, such as the financial statements. One, authorities may take a view that if the bet amount that is won by the website, net of the losses by the website, if that is shown as revenue earned by the website, that qualifies as a consideration received by the e-commerce operator. That's one view that can be taken to support view one. Whereas the second view is that since no service fees is being charged, where is the question of consideration being received by the website? So again, very a gray area in terms of the direct tax aspects as far as online betting is concerned. If I may request Sudipta to cover the indirect tax aspects on this.
Sure. So the same dilemma, frankly, arises in GST as well, but in a slightly different route. We reach the same question, but in a slightly different route. But let me start a little, with a bit of context setting. Online gaming, I think we are, for the purposes of this session, we are focusing more on the online part of it. But the lot of the litigation in GST vis-a-vis online gaming has commenced or focused around the gaming part of it. And why is that? GST, as we know, is on triggers on supply of goods and services or services. There is an exclusion for actionable claims. The definition of actionable claim we have already discussed. From that exclusion, so transactions in actionable claims are excluded, but from that exclusion, there are 2 or 3 exceptions. Lottery, betting, and gambling are those exceptions. So if the transaction is of an actionable claim pertaining to lottery, betting, and gambling, we are reverting back to the GST fold, and those are not excluded from GST. So this is where the debate, and many of you would know that in the context of gaming, the largest debate that happens is it a game of chance or is it a game of skill? So, fantasy football or cricket leagues and many of the other games that are typically played are games of skill. Whereas in our case study that we have taken, we are purely dealing with gambling, which is a game of chance. How does that make a difference? When it's a game of skill, typically you would see platforms charge two kinds of revenue streams, or there are two kinds of money flows. One is a platform fee, which is for the participation, the right to participate. And the second is the betting part of it, where you put in certain money as a part of a pool for a right to win the entire pool once the game is over, once that game of skill is over. When we are talking about game of skill, that entire pool part of it, being actionable claim, goes out of the net of GST. And it is only the platform fee that is, or that should be, liable to GST. This is one part of the discussion. When we come to lottery, betting, and gambling, typically a platform does not charge a platform fee. You are putting the entire money as part of the winnings pool. And unlike in the other scenario, unlike in a game of skill scenario, this actionable claim, the right to win, the actionable claim of right to win is not excluded from GST. So that becomes liable to GST. The question that arises is the entire 100, the face value of the bet, liable to GST? Okay. On that point, there is a divergence of views. Let's see what the law says. There is a specific valuation provision for lottery, betting, gambling, and horse racing. This horse racing is an anomaly because horse racing has been held to be a game of skill, not a game of chance. Lottery, betting, gambling can be clubbed under one category because they are purely games of chance. We have Rule 31A3, which says that in these four scenarios, the actionable claim, the value of the actionable claim in the form of a chance to win in betting, gambling, horse racing shall be 100% of the face value of the bet. Now, this provision was challenged by the Bangalore Turf Club before the Karnataka High Court, and a single judge bench fairly recently, this year itself, said that this rule sort of goes beyond the statute in as much as horse racing is a game of skill. It has been plugged into this as an anomaly. And in any case, GST is a transaction tax. If you look at section 15, the GST can only be levied on transaction value. One can include or reduce a few things from a transaction value, but you cannot say that the entire value of actionable claim becomes liable to GST. At least section 15 does not permit that, and to that extent, this was held to be ultra virus. Unfortunately, this has been stayed in September by a division bench, and they are sort of further deliberating on it because you will mentioned about the skill lotto judgment of the Supreme Court. I think there are observations which sort of support this particular rule. Be that as it may, I think what we are trying to say is the issue as to whether the entire pool would be liable to GST or not is open. Whether it is online, whether it is offline, this is an issue that is there vis-a-vis gambling services. Now, let's juxtapose this in the context of YDAR. Will these services qualify because it's a foreign sort of betting company or services being provided from outside India? It does qualify as YDAR, undoubtedly. But as I mentioned, YDAR is a place of supply concept. What is the rate that you will apply on the GST that becomes applicable? Before that. So what happens if it's an YDAR for whom people like you and me are the customers? Like we saw, the betting company or the site will have to take registration in India itself or through a representative and discharge GST in India. At what rate would it discharge GST? Because it's betting and gambling, the rate applicable is 28%. For games of skill, it is 18%. For games of chance, it is 28%. And then the next big question is on what value? If it levies 28% on the entire sort of pool value, the face value of your bet, I don't think it earns anything. Basically, the entire thing will go. And this is a large debate that is happening for all gaming companies across India. So this will be an issue that will arise. So undoubtedly, if we only focus on the online part of it, yes, it is an YDAR. It is liable to take registration in India and pay GST at 28%. What is the taxable base? That point is a little unclear. That point is a little unclear, and to that end, there is a group of ministers has been formed by the GST Council to deliberate on this specific issue. Because this issue, some of you would have read the various litigations that Dream11 has fought across the country, across various high courts, and was in fact won most of them, all of them in fact. But this is one point that has been left open from all of those litigations. The game of skill versus game of chance debate has been settled. How GST applies has been left open. So how an online gaming platform will pay GST in India, I think there is a bit of ambiguity remaining on that. But the fact that it will be liable under OIDAR and liable to pay GST in India, registered in India itself or through a representative, I think that point is fairly clear.
Thanks, Sujita. So yeah, I think here there's alignment in direct tax and indirect tax, that there is ambiguity on the applicability. And yeah, this is fairly a general trend that we can see on taxation of digital economy generally, because these models are new. I mean, and every day you have newer models coming, but legislation needs to keep pace with these newer models, and I think that's really the challenge here. And the last case study that we'll be covering is on intra-group SaaS transaction, and it's a very common sort of arrangement or model among MNCs. SaaS essentially stands for software as a service. So even something like, as an example, most of us are seeing the Taxmann. So maybe something like an online tally would also qualify as SaaS. So here the facts are that ABC Co is the central procuring company of a group of ABC Group, and it enters into a master service agreement with US Co for certain SaaS supply to various group companies across the world. The SaaS supply could be any accounting service, it's basically access to a software application which could be on anything. And the arrangement is that US Co would be providing these the access to the software application to various group companies of ABC Co across the world. But the agreement is only between US Co and ABC Co in the form of a master services agreement. Now, ABC Co has a group company in India called ABC India, and ABC Co cross charges ABC India for the SaaS access obtained by ABC India from US Co. Why is there a need for cross charge? Because US Co is basically billing to ABC Co, and ABC Co therefore is onward billing that, or rather cross charging that particular cost to ABC India. Now, the issues we've considered here for examination here are: number one, would any income tax be payable in India on the cross charge from ABC Co to ABC India? Number two, would 2% EL be payable on any leg of the arrangement? And number three, whether GST would be payable on this transaction. Now, again, dealing with first with the direct tax aspects. Firstly, as we discussed, in terms of priority, whether it will qualify as FTS or royalty. As far as royalty is concerned, basis Supreme Court decision in engineering analysis, one can say that it should not be chargeable as royalty, because this is a software service being given, and the Supreme Court's decision in engineering analysis was quite clear in saying that the medium of delivery of the software does not matter, whether it's through the physical medium or online medium. The concepts there in terms of the provision being for that of a copyrighted article rather than rights to copyright, that would stand. So on that basis, a view can be taken that it should not be exigible to royalty. And then we move to analysis of for 2% EL applicability. Again, 6% EL applicability should not apply because this is not related to online advertisement. Here, as Raghav had discussed, there are certain components. One is who is the e-commerce operator and whether e-commerce supplier services is provided or not. Now, in this, who is the e-commerce operator? Now, we can assume that ABC Co in this example does not own, operate, or manage a digital or electronic facility platform for online sale of goods or online provision of services, and hence ABC Co is unlikely to satisfy as an e-commerce operator. As you can see here, it's US Co which is really providing access to the software application, and US Co will meet the definition of e-commerce operator as it is operating, managing the facility for providing software access. But then the next question is e-commerce supplier services, ESS, and so provision of SaaS would certainly qualify as e-commerce supplier services, under the bucket of online provision services. Even online Sale of goods, maybe one may say, because one of the judgments of Supreme Court has held that software amounts to goods. But is USCO receiving any consideration for providing ESS to ABC India? That's the third limit that has to be satisfied. And if because here, if we see USCO is actually receiving consideration for providing consideration from ABC Co. That is the arrangement. And one of the as we saw in the definition of, or rather the charging section of 2% EL, the consideration has to be received for providing e-commerce supplier services to a person resident in India. And so when we do a finer reading of the charging section, it does not suggest that the e-commerce operator must receive consideration only from the Indian resident recipient. The requirement is just that the e-commerce operator must facilitate the e-commerce supply and to an Indian resident, and it must receive consideration. It does not exactly specify who should be the person paying the consideration. And so here again, two views are possible. View one, if the master service agreement reads that USCO will be providing the service to ABC Co and or its affiliates, adopting a literal interpretation, one can say that USCO is the one who's providing services to ABC India. And if such a view is adopted, the amount on which USCO should pay 2% EL would be the consideration received by USCO from ABC Co. So the first view is basically adopting a literal interpretation of who is the one who's really providing the service to the Indian resident. The second view is that in the absence of a contractual relationship between USCO and ABC India, USCO cannot be considered as to provide services to ABC India. And if this view is adopted, 2% EL would not be payable by USCO. And so this is taking a more, instead of literally interpreting the law as such, what you're doing is you actually are examining the substance of the transaction where there is no contractual relationship between USCO and ABC India. So again, two views possible. In the exact facts of the case, exact reading of the master services agreement would determine finally about the chargeability of 2% EL. Sujita, if you could cover the indirect tax aspects here.
Right. Well, the same debate sort of. Am I audible?
Yes, Sujita.
No. Okay. Well, the same debate arises even in the context of GST. The answers, thankfully, now are much clearer, because this is an issue that has arisen right from service tax era in the context of indirect taxes, and now the conclusions are clearer at least definitely compared to income tax. I'm not saying no dispute can at all arise, but more or less because recipient has been defined as someone who receives the consideration, and we have seen that GST being a tax which triggers on supply of goods and services. Here clearly there is no privity of contract between USCO and ABC India. ABC India is receiving the services from ABC Co in return for the cross charge amount that ABC India is paying ABC Co, and to that extent it is unlikely to qualify as a YDI services. But I mean, even if it does, it frankly would not matter, because it is being imported in the course of business, and to that extent liability, if any, will be on ABC India on a reverse charge basis. So it's relatively simpler when it comes to GST. And with that, I think we'll request Raghav to come back in and take us through the crystal ball gazing.
Thank you, Sudipta and Jugal, for a wonderful insight into the nitty-gritties of how taxation will actually work for digital transactions. I'm sure that people would have understood that, given the different types of legislative provisions that are operating in this field, interpretational issues and practical challenges are bound to come. So in terms of other key developments in the field of digital taxation, one important point to note is that recently, majority member countries of the OECD G20 Inclusive Framework on BEPS, which includes all G20 countries, agreed to a statement on two-pillar solution to address tax challenges arising from the digitalization of economy. Now, earlier this year, in July, also a statement was released that was an in-principle approval by different countries. And now there have been some more developments on that front. You would have come across news reports that majority countries have agreed to a global minimum tax rate of 15%. Ireland has agreed to give away its much cherished 12.5% corporate tax rate. All those are big developments that are taking place in the field of international tax. Now, the October statement, which is the most recent update in this field, that provides that as many as 136 countries out of 140 members of the inclusive framework have joined hands for this global commitment. India is also part of this. So let us see what does this development entail and have in store for us. Currently, the 4 countries that have not yet joined the statement are Kenya, Nigeria, Pakistan, and Sri Lanka. At the outset, this statement reflects a global agreement on significant changes in the rules for allocating taxable income of multinational groups between countries and introduction of new rules so that M&E groups pay a minimum level of tax regardless of whether they are headquartered or located in country A, country B, or anywhere else. Now, the statement is based on a 2-pillar solution which was proposed by the OECD Secretariat in October last year. The first component, Pillar 1, that seeks to create a new taxing right for market jurisdictions in the form of share of residual profit or share of excessive profit, whereby once a M&E group's profit reaches 10% of revenues, market jurisdictions would be able to tax 25% of the profits above that level. In tax terminology, this is being regarded as amount A. So if I take an example, what this means is that if an in-scope M&E group's profitability is 30%, then the residual profit will be 20%, that is 30% minus 10%. And 25% of such residual profit, that is 5%, will be allocated to market jurisdictions as part of Pillar 1. Now, Pillar 1, this profit allocation will be done to only those market jurisdictions where such M&Es derive substantial revenues, and there are thresholds in terms of revenues being prescribed for this purpose. To ensure that this covers only the largest and most profitable M&Es, a threshold of global turnover above 20 billion euros and profitability above 10% are also set for its applicability. In terms of numbers, the amount of M&E profits that will be reallocated to market jurisdictions each year pursuant to this is estimated to be more than $125 billion, and that is a very big number from the perspective of global taxation. Now, the point to note here is that in the July statement, it was mentioned that 20% to 30% of such residual profits would be allocated to market jurisdictions. So it seems that the global consensus now has been to take a middle rate of 25% of residual profits to be reallocated. But I think still that's a big step in the direction of ensuring that market jurisdictions get a fair right of taxing virtual economy profits. Now, Pillar 1 has another component, amount B, which aims to standardize the remuneration of related party distributors that perform baseline marketing and distribution activities in a manner that is aligned with the arm's length principle, with a particular focus on the needs of low capacity countries. And to provide tax certainty, an elective binding dispute resolution mechanism will also be made available for issues related to amount A for developing economies. One important point to note here, and that's very important point from India perspective, is that the statement also provides that countries will be required to withdraw all digital services taxes and other relevant similar measures with respect to all companies, and to commit not to introduce such measures in the future. So what will happen is that no newly enacted digital services tax or any other relevant similar measure will be imposed on any company from 8th October 2021 and until the earlier of 31st of December 2023 or the coming into force of the implementing multilateral convention, that is MLC. So, from the face of it, it appears that as part of this global commitment, India may have to let go of its equalization levy, and that will be an important development in Indian taxation regime. Interestingly, the Pillar 1 proposal does not differentiate between the digital and non-digital businesses. The Pillar 2, now if we move to the next one, that is Pillar 2. Now, Pillar 2 addresses remaining BEPS challenges and deals with the global minimum tax rate for large internationally operating businesses. Pillar 2 has two elements: global anti-base erosion rules, that is GLOBE rules, and the subject to tax rule, that is STTR. At a broad level, I think we can say that GLOBE rules provide that if the income of a constituent entity in the M&E group is taxed at below an agreed minimum tax rate, the residence jurisdiction of the eligible parent entity will be able to levy an additional tax, a top-up tax, to the extent of difference between the effective tax levied and the agreed minimum rate. The statement provides for a minimum tax rate of 15%. In terms of numbers, again, very big numbers, the global minimum tax at 15% is estimated to generate $150 billion in additional global tax revenues per year. So we are talking about big numbers moving from one country to another country in this scheme of things. If I take an example, what this means is that if a MNE group's effective tax rate is say 11%, and the residence jurisdiction of the parent entity will be able to levy the differential tax of 4%. Now, what this will do is it will disincentivize the multinational groups to set up base in jurisdictions purely for tax benefit reasons. Another point to note for this component is also that in the July statement, it was mentioned that the global minimum tax rate will be at least 15%. So, I mean, once again, it seems that the global consensus has been to adopt the least possible number for global minimum tax rate as of now. Now, the globe rules will apply to MNE groups that are required to undertake country-by-country reporting under the applicable transfer pricing regulations, which essentially covers multinational groups having annual consolidated turnover above 750 million euros. That's approximately 6,600 crore rupees. The statement adds that countries are free to apply the minimum tax rate principle to multinational groups headquartered in their country, even if they do not meet the aforesaid threshold. And to ensure the materiality concept, globe rules also have a de minimis exclusion for those jurisdictions where the multinational enterprise has revenues of less than 10 million euros and profits of less than 1 million euros. On the other hand, the STTR, that is the subject to tax rule, that will allow source jurisdictions to impose limited source taxation on related party payments that are subject to tax below a minimum rate in the residence jurisdiction. The rate for this purpose has been decided at this point of time to be 9%. In terms of timeline, the statement lays down the following manner of implementation, and I think I'll just touch upon briefly as to what is the implementation timeline. So, in relation to Pillar 1, Amount A will be implemented through a multilateral treaty. The statement provides that it will be developed and open for signature in 2022 and becoming effective in 2023. A sort of similar timeline for Pillar 2, which will... So basically, these rules are likely to be effective from 2023. From an India perspective, it is very important that while India has been in favor of such a consensus-based solution, it has always maintained that the solution should result in allocation of meaningful and sustainable revenue to market jurisdictions, particularly for developing and emerging economies, because that's a very important component of country revenue for these economies. So from this perspective, I think government will need to test whether the share of tax revenues gained from pursuant to the two-pillar solution outnumbers the tax revenues that will have to be foregone on account of withdrawal of digital services taxes. From indirect tax perspective, Sudipta, do you feel that there are key developments that one should look forward to in future in relation to digital economy?
So frankly, I think the GST laws, if we look at it, are fairly futuristic. In fact, they have been at the forefront. They have been very quick to respond. The concepts that we saw, OIDR as well as the e-commerce operator under 9.5, I mean, they are carry forward of similar comparable concepts under service tax, and they have been around for about 7-8 years now. If we look at the global sort of developments in this, whether it's OECD, UVAT, many of the papers that are coming out, the policy level developments or changes that they are envisaging are more or less there in some form or the other in India. And if you look at the two-pillar solution, frankly, from a GST perspective, it may not make much of a difference because, as I keep saying, it's a transaction-based tax. And to the extent, as far as the point about allocation of revenue to the market jurisdiction concept is concerned, if I have to translate that in a GST concept, it is basically where the consumption is happening or where the recipient is located. And like we saw in the context of YDAR as well as some of the other things, that sort of net is already cast when it comes to GST. I think the only thing we can foresee going forward is greater clarity as more and more items or supplies get covered under, I mean, as we say Uberization is happening or Uberization is the future. As more and more Uberization happens and 9.5, the notified areas under 9.5 increases, government would have to clarify on a very key aspect, which is as under, there are a lot of supplies or services where a concessional rate of 5% is available on the condition that credit of input tax on goods or services has not been taken. The question arises, does this apply only to an actual supplier, or does this also apply to someone who is paying under 9.5? because in under 9(5), e-commerce operator is stepping into the shoes of the supplier for payment of GST. The question that arises is, does he become bound even by the credit restrictions on that leg, on the supplier's liability? How far do we take the deeming fiction of 9(5) just because the e-commerce operator is wearing the hat of the driver or the restaurant, whatever it might be? Do I become restricted by the same credit restrictions as a passenger transport service provider or a restaurant would have been? I think this is one open item where varying positions have been taken by multiple parties, and it would be, really useful if a clear position emerges on this point. I think that is all that one can say vis-a-vis crystal ball gazing from a GST perspective.
Understood. So, to summarize today's session, we learned about the tax implications, direct tax as well as indirect tax that are applicable to digital economy and e-commerce transactions. We understood the statutory provisions with the help of some practical case studies. I'm sure the viewers would have definitely appreciated and liked the nitty-gritties, how taxation is working in the different types of e-commerce transactions. Certainly, this sphere of taxation is only going to get more interesting and complex in times to come. The fact that this involves international tax and cross-border aspects also makes it even more intriguing. As I said earlier, from an India perspective, a very important development that needs to be watched out is the fate of India's Equalisation Levy in the next few years, considering our global commitment as part of the OECD's two-pillar solution. Evidently, a cost-benefit analysis will need to be undertaken by the government to, analyze the taxes gained as part of the two-pillar solution as compared to the taxes that will need to be sacrificed. Worldwide, people are now recognizing that our large population base provides us with the biggest ammunition and contributory factor in negotiating a better share of global tax revenues. And all these developments that are taking place at a global level are demonstrating that the traditional FAR approach in income tax, that is, functions performed, assets employed, risks undertaken, an approach which is used to determine value creation, it considers supply side factors only and not demand factors. And that's where there was a tilt against the market jurisdictions. But what is happening? These developments are recognizing the concept that market jurisdictions also enable value creation, and that therefore FAR must transit to FARM, that is FAR plus market. Only time will tell how this actually plays out. But like any new piece of legislation, the laws in this field may also have some teething issues, the interpretational issues, the practical challenges, and hopefully they will be resolved soon. But one thing is certain, as of now, digital economy is perhaps one of the most interesting, challenging, and fascinating segment of global taxation architecture that we are facing. And I think both Sudipta and Jugal will agree with me 100% on this point. With this, we would like to end our presentation for today. I'm seeing that there are some questions on the chat box. We can, though we don't have much time, but we can at least take some of them right now or offline separately also. One of the questions was whether EL2 needs to be remitted by the Indian payer, or the liability to pay EL2 is on the non-resident e-commerce service provider. So that bit is clear, that as I mentioned earlier, the compliance obligation of EL2 rests on the NR, unlike EL1, in which case in EL1 it is like a deduction provision. In EL2, the NR, the non-resident operator, has to pay the taxes on a quarterly basis, file the returns, etc. Then whether an online non-resident gaming company will be treated as an e-commerce operator and attract EL2, I'm sure Jugal will have very interesting views on this, because there are multiple views in this possible, as he explained on the case studies. There are multiple views which are possible, whether it is a game, whether it's a goods or service, whether it is online, and who is actually providing to whom, and how consideration is flowing. So I think there are multiple elements which, and how Jugal mentioned in the portion of his case study. Jugal, do you want to add anything, or have I summed up the confusion clearly?
Yeah, I think that's summed up correctly. I think there's one more question on Section 194, or what is meant by the term facilitation. and what all type of transactions are covered. So just as example, I mean, e-commerce marketplaces. So some of the common names that we have like Amazon, Flipkart, or you have our cab riding services, Uber, Ola. So I mean those kinds of services basically where they facilitate, where the person who is really selling the goods, say on a marketplace, is someone else, or for that matter on Uber, Ola kind of services where actually it's the driver who is providing the service. So those are the kinds of I mean basically marketplaces. That would be a good summation of what type of transaction would be covered.
Correct. And then there was one bit on re-explanation of the significant economic presence SEP concept. So just, I mean, though we had discussed that in the initial bits, very briefly, if I have to touch upon that, SEP is basically trying to tax foreign enterprises who have virtual presence in India and who are gaining from their virtual presence in India, who are earning profits. And right now they are not being taxed because of I mean, whether to use the word loophole or inadequacy, but the current tax provisions do not envisage such a business model. But since this segment of economy and segment of taxation has become very important, very big, the domestic tax law has been amended to provide for a taxing right, and certain criteria are provided, like the user-based test or the payments-based test, like the 2 crore test or 3 lakh users test. But the only problem or the way out for foreign enterprises that was happening because of this is that this finds place in the domestic law. Now, as we all know that in the case of international tax, domestic tax law or the tax treaty, whichever is beneficial, will apply to the foreign enterprise. Since our tax treaties right now have not been amended, the taxpayers who are able to either eligible for tax treaty benefits, then for them basically SEP becomes academic, because then they'll say that, okay, even if I fall within the SEP ambit or within the SEP trap under the domestic tax law, but if I'm able to get treaty relief, I automatically come out of that. Now, some people call this as why did India do this sort of a thing, that why did India put this in the domestic tax law, whereas even knowing that any foreign taxpayer, when he or she, I mean, when the foreign taxpayer will be getting the relief under the treaty, they'll be automatically coming out of it. But I think the one larger at a policy level concept which we have to understand is that when India did this, it at least put its foot down that yes, we want to tax this sort of a business profit, and we are not letting it go. At this, the argument which people said that why did the government do this? Because we had a treaty to take out such taxpayers. The government flipped that point and said that, look, okay, what's the problem then? We have made it in our domestic provision, but if someone is coming from a treaty jurisdiction, that person will automatically come out of it. So at least we are not, since this is a domestic tax law provision, we are not violating our treaty obligations. But what happened is, because of that, set the tone for ensuring that big market jurisdictions like India are don't want to take this for right, and they want to ensure that they get a fair and reasonable amount of share of taxes from foreign countries' profits when it comes to when they earn the profits out of the virtual presence in market jurisdictions like India. Sudip, anything from GST or IDD perspective that is there? I think you answered one question, but if there's anything else, you can take it.
I think mostly I have answered. I think there's been one question on under OIDR of whether the authorized signatory or representative has to be a resident or non-resident. So there is no clear guidance, but if you look at the GST law, it talks about someone in the taxable territory. That sort of a language is being used, and practically, I mean, if you see how they are doing the KYC, etc., it is a resident who has to be appointed. So, but it's not exactly flowing from the statute. If one has to challenge that specifically, one can, explore that.
Correct. I think last, I think we'll want to just touch upon one point that, there's one comment sort of a stroke question that, implementation of both the pillars may be critical in terms of having a group level global taxation. But as we all know that India currently does not have a group level tax. So globally, this may be challenging. I think that's a fair point. India currently does not have a group level of taxation, but what is happening? right? The current, and we have to exactly see how the multilateral convention, the implementing multilateral convention is worded. But one thing is clear, that at least a lot of, as I mentioned, the numbers, more than $100 billion of additional tax rights, more than $100 billion of additional tax revenues getting generated for it, only for direct tax bit. One thing is certain, that India is definitely going to gain a lot of money, but the only catch will be, we'll have to do that number crunching, that what we are giving away and what we are taking, whether there's some profitability element from a policy perspective or not.
And if I may add one thing here, is that even though India does not have group level tax, what the pillars really envisage, at least, I mean, okay, taking each pillar one really envisages that the share of the market jurisdiction, that is the share where the customer is located, say if it is India, while it will be collected by one at one entity level, at the ultimate parent entity level, it will be redistributed to the market jurisdictions. So for pillar one, India need not have a group level tax asset, because the treaty itself will provide for reallocation among the countries itself. And as far as pillar two is concerned, yes, over there the ultimate parent entity where it is located, that might benefit in terms of if the minimum rate of tax is lower. However, even pillar two provides for situations where if that minimum rate of tax is not met by at the ultimate parent entity level or any level below that, or I mean rather any level above India, even India can then enforce certain provisions are there in pillar two, such as under tax payments rule, or even STTR, where it can collect tax by itself. So the pillars basically have their own mechanism, which do not exactly require a group level tax to be done by each country. They envisage sharing of tax revenues among countries.
Vipin, I think this is from our side then. If there's anything else that you'd like us to take to the Taxmann team.
Thank you, sir. It was really a nice session, I must say. Thank you to Mr. Bhattacharya and Jugal as well. I must say, the way the entire topic is explained through various case study, it was really great and informative. I hope everyone participating in this webinar have benefited from that. I also thanks all the participants for joining us in today's webinar and making it interactive. We will share the presentation on your email ID, and if you missed out something, you can watch this webinar on Taxmann's YouTube channel as well. So once again, I thank you all the experts and participants. Thank you, sir.
Thank you. Thanks a lot.
Bye. Thank you.